Hey everybody, welcome back to the Court of Random Opinion. My name is Lauren Neidigh. We have some documents tonight relating to arguments over sealing and unsealing evidence in the Blake Lively versus Justin Baldoni and Wayfarer case. Blake Lively, who initially went to the New York Times before her lawsuit was filed, is a transparency crusader who suddenly discovered curtains. She rang the town bell and then asked everyone to leave the square because she doesn't want anyone to actually scrutinize what she's saying. The Wayfarer parties are asking that most of this evidence be unsealed. The judge has yet to rule on that, so we're going to have to wait and see what happens. But there were a bunch of documents that came out tonight. Last week was, they had to ask, the parties and non-parties had to ask the judge to continue sealing certain documents if that's what they wanted. And then today was the deadline for oppositions to that, basically saying, no, this should not remain sealed, and this is why. Tofo6916, thank you for the $20 Pacer bucks. Thanks, Lauren. Thank you. Appreciate that very much. We get our Pacer bill every 3 months or so mine's about due. So I appreciate that. I do. And I also saw Kim before we started the stream had given some like $10 or something like that. So thank you, Kim. Kim is always helping out. So I love Kim. All right. Tonight, I've been trying to limit my caffeine intake after 9 p.m., but I started before 9 p.m. tonight, which never happens. So we're drinking black coffee out of Bruce the Moose mug. If you guys don't know my buddy Bruce, I met him through Dave Neal's channel on the Laura Owens Clayton Eckert stuff. So here he is on my mug. Oh, that's disgusting. Not Bruce, but the black coffee. Oof. Okay. I'm always up late working, so thank you, Julie, as well for the Pacer bucks. All right, let's get into it. So lots of documents came out tonight. Some of them are not like things that we need to go through so much. So the Stephanie Jones documents that came out, the exhibits, are mostly pertaining to the case between, I guess, Rebel Wilson and Amanda Ghost. And it's not really that relevant to what's going on here between Justin and Blake. So I'm not going to go through that, but I will go through these letters that talk about why certain things should be unsealed in the case between Justin and Blake. Remember, Stephanie Jones, the publicist, her case against the Wayfarer parties, Jen Abel and the Wayfarer parties, is like a separate but related case. So there's a lot of stuff going on there that's not really pertinent to what's going on here. And I don't know much about the dispute between Rebel Wilson and Amanda Ghost, so I don't want to comment on that too much. So that is something that I will be doing at a different time. I think I might have my friend Ashley Brianna Eve help me out with that because she's a little more well-versed in it. But for tonight, we're just going to focus on this dispute between Blake Lively and the Wayfarer parties. So, all right, let's pull this up first. Hopefully my sound's okay. I had to move my stuff recently, so. Why black coffee out of milk? Because I'm trying to drink less milk and sugar. So it is what it is. All right. Also 5-hour energy because it has a lot of extra vitamins that I don't need, but I love it so much. So, all right. Thanks, everyone, for pitching in with the Pacer bucks, like I said. Anyways, let's move on here. Oh, and also, after this stuff, hopefully the judge will rule on this soon. I think he wants to try to rule on them before that hearing we have coming up in 9 days from now, I think it is. Was it the 21st or the 22nd? I don't know. But I have my flight out there because I was going to attend that if it's open to the public in person. Of course, if it's not and I find out it's not, I can always cancel and get a refund because I got, a flight that is refundable. But I haven't really figured that out yet. So if the hearing, which is an oral argument on the motion for summary judgment, and also on that sanctions motions for the spoliation sanctions, where Blake Lively is trying to say that the Wayfarer party somehow deleted evidence because they had an auto-delete function on in the Signal app for long before the lawsuit was ever filed. Those are things I'll be arguing, and I will attend that if possible. So, and then I know a couple other people who are going as well. Some are more familiar with the court system in New York, so they'll be able to help me out. But I got to wait and see what's going on there. But the first thing I want to read tonight is this response to Blake Lively's, motion to continue sealing stuff. We have a few motions, but we'll probably skim through most of them. But this one we'll read the whole thing. So give me 1 second here to take a sip of water, and then we'll get there. Danny says another one scheduled at 9. Is that something different? Yes. So I've made a video on their opposition to WME's request to continue sealing before everything else came out. So when this live stream is over, I'll redirect you guys to that video. It's only like 9 or 10 minutes long, so you can read that one. But I don't have it up. I'm not going to go over it now because there's so many other documents for us to look through, and also I already did a whole video on that. So when we're done here, I'll redirect you, and we'll do the premiere right away. So Shannon OS, thank you for the $20. Lauren, I've loved you ever since you recapped the dance montage video. Justice for Ponytail Lady. Ponytail Lady. Deserve better. All right. Thank you, Shannon. Anyways, let's move forward here. The Wayfarer parties write in response to Lively's motion for sealing. Lively carries a heavy burden in seeking to seal summary judgment and sanctions materials. The Second Circuit instructs it is not and should not be an easy matter to deny the public access to documents that are utilized in judicial proceedings and form part of the basis of judicial decision making. So, you know, the public funds the courts, and the federal judiciary is a branch of our government. So the standard should be pretty high for what you should keep private in that regard. I agree with that. This isn't like a private settlement. If you want to move it forward to trial and you have a genuine interest in fighting this out in court that the public funds, then you should have to show the public what's going on there. I have a different opinion when it comes to third parties and people who are not parties to the lawsuit, but you know, as far as Blake Lively goes, I feel like most of her evidence, if not all, should absolutely be made public. Okay. That is because public monitoring is an essential feature of democratic control. Monitoring, both provides judges with critical views of their work and deters arbitrary judicial behavior. Without monitoring, moreover, the public could have no confidence in the conscientiousness, reasonableness, or honesty of judicial proceedings. And I definitely agree with that. If you can't see why a judge made their decisions, if the public's not privy to that information that they fund and they rely upon for justice, then why would they trust those judges? Why would they trust anything to do with the courts if they're not able to see the decisions and the process of the court that they pay for with their hard-earned income every year? You know what I mean? So, all right. It does hold judges accountable. I mean, I think if a judge was ruling based on sealed information, then they could, you know, make decisions and excuse those decisions without any transparency, and that is a problem. So, and I'm not saying anything about Judge Lyman in particular there. I'm just saying that's the theory behind why we do things the way that we do. So, all right. Okay. The majority of Lively's requests fail to overcome the strong presumption of public access at this stage. Crucially, Lively cannot hide key facts of this litigation from public scrutiny simply because she finds them embarrassing or unhelpful to her case. And I feel like I'm way, way harsher on Blake Lively here than I am on any other like third party who wants to seal stuff to this case, because Blake Lively knew what she was doing when she went to the New York Times months before she filed the CRD complaint. When she filed the CRD and then, you know, put that out into the public sphere before a lawsuit was ever filed and it was ever being fought in court. She just thought that the people that she was fighting against wouldn't fight back. She thought that Justin Baldoni was a small potatoes who couldn't fight back, but Steve Sarowitz, his business partner, has the money and the means to fight it. So it just shows how people can abuse the court system if you have enough money and power. And that's how they maintain so much control. And to me, that's why it's so important to have transparency in court documents, right? If you're a party. Again, I have stricter kind of opinions when it comes to third parties, because I think it's scary to know that people could abuse the courts in a certain way to embarrass anybody, you know, who's not involved in the lawsuit. That bothers me. But when it comes to the parties like Blake Lively, you brought this out here. You knew that it was a possibility that this stuff would be, you know, viewed by the public. You just thought that your opponent was too small potatoes to fight you. And now you're having to find out that, oh shit, I actually have to reveal everything behind the claims that I was making. So I think that's a problem. Okay. I also have no sympathy for her in particular because she tried to bully random social media users and content creators who said bad things about her online with her money and status and the court's power. to get their bank account information, which not only affects them, but potentially their families or loved ones who share bank accounts with them, that kind of thing. Location data, all kinds of private information that you shouldn't be able to have. It's just like so insane that you would be able to do that. And yes, it sucks to be talked poorly about online. I have random people who talk shit about me online on those toxic subreddits, but like, you have to understand, like, who you are and know and have as much confidence as you can in yourself to know, like, hey, just because this person said a bad thing about me doesn't mean that it's true. And you have to be able to move forward with your life. And I feel like if she had done that, you know, we wouldn't really be here right now. But no, she tried to instead, you know, with the full force of the Streisand effect, subpoena 107 social media users who thought she did a terrible thing with this lawsuit and ruin their lives possibly through bankruptcy. Because if you have people who are forced to pay for lawyers to fight this, so that some random powerful celebrity with the full force of WME, etc., you know, behind them, will get your private information, like, you know, you're going to shell out money for an attorney, and at that point, it's like it could bankrupt you. So, I still don't understand how a case that used the sham lawsuit and fake subpoena could make it this far. Well, they didn't really know about the subpoena that much until well after the lawsuit was underway. At some point, there will be something called a motion in limine, which means they want to try to exclude certain evidence or certain witnesses or whatever from the lawsuit. I think that they will probably file to exclude that evidence that was obtained through the Van Zandt lawsuit. But I can't say that for sure, you know. Lego spawning floor, round room, no door, light, 4B out. What? I don't know what that means, buddy, but thank you very much. It's good to see you. Okay. All right. Let's move on with this document instead of my pointless rambling. Okay. One sec. Okay. Anyways. As detailed in an accompanying chart that will be separately submitted to the court, the Wayfarer parties agree that certain financial information concerning the film and non-parties, as well as information that could implicate Hoover's privacy, should be sealed. So they're being reasonable here. Separately, the Wayfarer parties do not object to sealing references to true non-parties, such as actors who were considered but not chosen to appear in the film, and that to me makes sense. Sealing names of people who were not involved in this whatsoever definitely makes sense to me. And other JonesWorks clients, the Wayfarer parties also take no position on the sealing of one's witness's medical information, although such information should be disclosed if the matter proceeds to trial, as it bears on the witness's credibility and knowledge. Now, I couldn't tell you exactly what condition that would be, obviously, and I don't know who exactly the witness is, but if they're saying it would, you know, relate to their credibility and knowledge, I wonder if it's something that affects memory or some shit like that. I don't know. Or some sort of mental health condition. But Lively's sealing requests go well beyond these narrowly limited and well-established exceptions to the public's presumptive right of access. Lively seeks to hide from the public the identity of key witnesses, people she herself involved in this dispute because of who they were. Famous, powerful Hollywood players who uniquely commanded enough influence to convince Sony to take a film away from its director, Baldoni, and try to destroy his career. Chief among these claimed non-parties is Lively's husband, Ryan Reynolds, the subject of her sealing requests in Wayfarer motion for summary judgment exhibits, and then they list the exhibits there, and Wayfarer spoliation opposition exhibits, and then they put that one there. Reynolds is not an innocent third party by any stretch of the imagination. He is the proponent of the Rule 11 sanctions motion at issue here, right? He still has an outstanding motion in this case. What do you mean he's not involved? Yet he has asked the court to seal nearly all of the documents submitted with the Wayfarer party's supplemental opposition to that motion. So he's saying, here's a motion saying that the judge should sanction these people for XYZ reasons, but in the response to that, where they're saying, no, sanctions are not appropriate because Ryan Reynolds says, well, the public shouldn't get to see the reasoning behind their motion, their response. The public shouldn't get to see why they don't think that sanctions are appropriate. So, In seeking to protect her husband, Lively relies on, and there's a court case here, it says that case is entirely inapposite. There, the court redacted the identity of a potential customer who was not affiliated with any party and not accused of any wrongdoing. So that's not exactly in line with Ryan Reynolds. Here is it. All right, one sec, guys. Guys, I don't know if I can do the black coffee anymore. I'm trying. I'm going to finish this cup, but that might be the best I can do. I might just have to go back to cream and sugar. So I have one of those little Keurigs, and I tried to use it, and yikes. It doesn't taste good. Not without anything in it. Anyways. If anybody has any suggestions, please email them to me so that I don't have to gag every time I take a sip of coffee at night. Okay. All right. See, where did I get to here? From the outset, Reynolds involved himself in the production of the film and Lively's objections to it. He secretly rewrote the film's pivotal rooftop scene under Lively's name. So that right there, like, they were on a writer's strike, and the fact that he did that in general is just shitty. And then the writer who actually wrote the scene found out in like an interview or some shit like that. Which is hilarious because the female writer was complaining about the Wayfarer parties not giving her enough power and influence, but Blake Lively's husband, another man, rewrote the scene without her consent or knowledge, or anyone's consent or knowledge, and they only, put that out there in an interview later on for attention. So, big yikes. All right. Anyways. He, Reynolds, berated Baldoni for supposedly commenting on his wife's weight before shooting began, which is the subject of her claims. He participated as Lively's designated representative in the all-hands meeting to discuss Lively's objection months later. The very documents Lively now seeks to seal make plain that Reynolds continued to deliberately insert himself into this dispute. And then there's a redaction here, and after the redaction it says, They have to, by the way, guys, keep some stuff redacted until the judge rules on this, because they're disputing over redactions right now. So there's not really much they can do about that. It says, long before the Wayfarer party's alleged smear campaign supposedly began. After the premiere, the messages show that, and then redacted, unfortunately. In at least one instance, it appears that, again, redacted, Lively has asserted marital privilege over her communications with Reynolds. Of course she did. And it's funny because she didn't have any problem like blasting anyone's communications between whoever to the New York Times. And now she's like, well, you shouldn't be able to see text between me and my husband. No, I think that if you bring something voluntarily to the court, this is not a criminal case where she's being tried and she has to show evidence and stuff like that. It's not like they're not asking Ryan Reynolds or Blake Lively to testify against each other in a criminal case. My personal opinion is that if you bring something to a civil court like this that the public is funding, you should not be able to hide your communications based on marital privilege. That's just my thought. So, and I know other people will feel differently about that, but that is how I feel. So, all right. It is fair to infer that Reynolds' communications to third parties were made with her consent based on the information she provided and on her behalf. So there's communications between Ryan Reynolds and WME that they want to unseal. WME is, of course, opposed to that. Ari Emanuel, who was at that point the head of WME, I think the CEO, I'm not positive if that was his title, but he was at the top, let's put it that way, went to film a podcast. I can't remember which one it was, but he, behind the scenes of that, or well, it wasn't even behind the scenes, while they were filming, said something about firing Justin Baldoni based on what Ryan and Blake said about him. And that was never supposed to see the light of day. They never thought that would get out. They edited that out before they put the podcast out. But somebody who was in the audience for the live recording leaked it. So they found out. Ari Emanuel admitted that Justin Baldoni was fired, or let go from WME because of what Ryan Reynolds and Blake Lively said. So, all right. And although Reynolds was not deposed, there was no dispute that he is a key witness who may well be called if this case proceeds to trial. Both parties named Reynolds on their initial disclosures. And on the disclosures, they're saying, like, who might have what information related to the lawsuit. So, like, Taylor Swift apparently wasn't deposed. I guess we can't for 100% certain say that. The judge never said she couldn't be deposed. He denied an extension for the deposition. But if they were able to work out a time where she could be deposed over Zoom or something within the normal time frame, maybe she was. So I can't totally say she wasn't. It sounds like she wasn't, but I'm not sure. So like there's people who weren't deposed who were named in disclosures. So just because they were denied an extension doesn't mean Taylor Swift can't be used as a witness at trial. Just like Ryan Reynolds. So people ask, and I will say this, why didn't Blake Lively, her side, have Ryan Reynolds deposed if they thought he was so relevant? The thing is, they don't have to do that. Blake Lively already knows what Ryan Reynolds is going to say. So they don't need a deposition to know what Ryan will say as a witness at trial. They could just call him as a witness and feel fully confident in what he will say and what information he has. The Wayfarer parties, however, if they were to depose him, they would be asking questions to find out what he knows, what happened, what he might say, and how that would work out for them at trial, what they might have to say to discredit him, that kind of thing. But Blake Lively doesn't have to do that because she has the privilege of being married to the man, so she knows everything that he might possibly say. So there was no point in Blake Lively deposing Ryan Reynolds. Whereas the Wayfarer parties, if they wanted him to be some sort of, they wanted to ask questions at trial, they would have had to depose him. That doesn't mean that he can't be used as a witness. It just means they don't think he has enough information for them to have deposed him. They already know what they're going to do with him or not. But Blake Lively using Ryan Reynolds as a witness at trial is still a possibility. It's just that she doesn't need to have a deposition for him to know that what he's going to say, if that makes sense. So, all right. Lively offers no basis for sealing Reynolds' communications beyond her fatuous claim. What does fatuous mean, guys? Hang on. I have never seen this word. Fatuous. Silly and pointless. Fatuous. Weird. Okay. Sorry, I've never seen that word before. Anyways, beyond her fatuous claim that he is not really involved in this case. The information at issue does not disclose anything private or especially sensitive. Rather, Reynolds primarily discusses, and then it's redacted, unfortunately, a subject that has no bearing on his own privacy concerns. Lively also seeks to hide the identity of the famous people she recruited as advocates on her behalf against the Wayfarer parties in her attempt to take over the film, and that's where it gets good. The footnotes down here says there's a redacted name that says it's an alias for Reynolds. Like, we unfortunately know now that Henny Grace, I think, is the alias for Justin Baldoni. You see it in a lot of the text messages. So the publicist will have like his name as Henny Grace in there, but no, it's Justin Baldoni. Ryan Reynolds also has an alias, I guess. They'll like book things under the alias names and send messages under the alias names so that their clients aren't outed publicly. I understand that. I think that's a good strategy because these guys have to stay away from crowds somehow. So the Wayfarer parties have no objection to replacing the alias name with Reynolds' names. So they're saying even if we unseal this, we can still replace Ryan's name with the alias name so that his alias isn't exposed. So that makes sense. Lively asserts Wayfarer MSJ Exhibit 205 and 211 reflect private information about her family. Okay, Lively has not identified such references and none are apparent from a review of the text. So basically they're saying she's like asking him to seal stuff that has private information about her family, but there are no apparent references to her family when they reviewed the text. Let me check the bottom here. Yep, we're good. Okay. So, 1 second here, guys. Gotta have some water to wash down that black coffee. Okay. But information ought not be sealed or redacted solely because it may harm a party's public reputation or celebrity status. And I agree with that. Just because someone is a celebrity or famous doesn't mean they should have any, bigger rights in court than the general public, in my opinion. I know that it sucks to be a third party in a court case, and I personally advocate for privacy when it comes to third parties. But if the general public who face court cases every day, especially like ugly custody cases and shit like that, have their public messages like or their private messages blasted out to the public. Sorry, a pop star or a celebrity, an actress, shouldn't have any more privacy than a random member of the public, especially because the public is the one paying for these courts, for these processes. It's just not, it's kind of, if this were some sort of private scenario where they were going through some sort of private arbitration, then of course they could keep everything private, right? But like, they're not. They're bringing it to the taxpayer-funded public courts. And so I don't think it's right for a celebrity to be considered, to be given more of a privacy consideration than a random member of the public who gets dragged through the courts by their ex. You know what I mean? So it's like, we all have to face this every day. And a very rich person like Blake Lively could subpoena your bank account information, like she tried to ask for my credit card numbers and shit. And I couldn't afford a lawyer for that. I had to fight it myself. I had to file my own motion. I had to do the research. I was up after work hours. I was like, I wanted to spend time with my family, and I had to stop, and I had to sit in my house Googling and researching stuff to try to fight it myself and figure out what I could do to prevent this lady from getting my credit card information. So like, no, I can't afford an attorney, and I'm forced to deal with that myself. So I don't have a lot of sympathy for random celebrities who are like, well, I'm so special that the public shouldn't get my information because that would suck. It would suck for me too. It would suck for me because I can't afford an attorney unless I want to go bankrupt, right? But I still had to do it. I still had to go through the process. And I still had to publicly respond to Blake Lively's subpoena so she didn't get my fucking credit card numbers and my location data from before I ever talked about her lawsuit. It sucks, but you have to do it. And if I have to do it, then so should they, in my opinion. Yes. I think that if the public has to fight for their privacy rights, then these celebrities shouldn't have any more rights than we do, because we're the ones who pay for it. So, sorry, sucks for you, but sucks for all of us. You know what I mean? It sucks for everyone. If you want reform on that front, if you want to not have to disclose that kind of information, advocate to change the legal system, advocate to change things to better the system for everybody, not just rich, famous people. But Blake Lively filed this lawsuit and went forward with this knowing that this could happen, and she didn't care. So that's a Blake Lively problem, not a public problem. Sorry about that. Okay. Give me 1 second here, guys. Okay. And we'll get more into the celebrities down here, but witness identities are shielded from the public only in rare circumstances, such as where there is a danger of impairing law enforcement or some credible safety risk. There is nothing comparable here. Moreover, not only are these individuals key witnesses in the case, but their identities are essential to enabling the public to understand the Wayfarer party's defense. Lively did not merely vent her frustration to friends. She sought out people with immense influence in the industry, and she explicitly weaponized that influence against the Wayfarer parties. So let's just point this out right here. Did not merely vent her frustration to friends. Even if she was just venting her frustration to friends, even if she was just talking about this stuff to her friends, what she says there matters. So, like, if she told her friends something that was different than what she put out in the public eye, that matters. Her private conversations, if she's admitting that there's a difference between what she told the public and what she said in private, that matters. So even if it was just venting to her frustration to her friends, she has blasted the Wayfarer party's conversations with their friends, everything about, like, the things that they said about each other, potentially ruining their relationships and their livelihoods and hurting their reputations. She has blasted everyone's private messages about their friends out there and said, this is relevant public information. This is fine to show everybody. But then she's like, oh no, people shouldn't just be able to see what I say to my friends in private. Well, you had no problem weaponizing your influence to blast people's private information through what I firmly believe to be an illegal lawsuit that you used. You abused judicial process, or not judicial process. They didn't even have a judge assigned. You abused the court process to get text messages off of somebody's phone, another woman, coming from the woman who claims this is some sort of sexist thing, you grabbed the text messages from another woman's phone and then blasted them to the New York Times to ruin her reputation. Like, I don't have a lot of sympathy for you. If you're saying, no, my private communications, okay, what about my private credit card numbers? What about my private location data? What if I don't want everyone and the courts and your lawyers, who seem like shitty people, to know where I have been at all times from months before your lawsuit started on? Like, what the fuck? It's just crazy. Okay. Okay. Moreover, Lively had no qualms about publicly divulging identity of other famous people in whom she apparently had confided. And then they say, see dockets 913-1-2, identifying inter alia Emily Blunt, Alexis Bledel, America Ferrera, Gigi Hadid, Hugh Jackman, Taylor Swift, and Amber Tamblyn. It is only now that the messages place Lively and her friends in a negative light that she seeks to hide their identity. Lively should not be permitted to use sealing tactics as a sword and shield in this manner. She can't attack people with this stuff and then be like, oh, I defend myself by sealing. You know what I mean? As this court has acknowledged, a generalized concern of adverse publicity is not a sufficiently compelling reason to outweigh the presumption of access. That is particularly so at this stage of the process when, as this court has rightly stated, the presumption of public access is at its peak. And why is it at its peak? Because she went to the New York Times and wanted this to be her, like, Me Too debut. She wanted to be the face of Me Too 2.0 with her claims and went to the New York Times expecting that no one would fight back. And it bit her in the ass. So, of course, the presumption of public access is at its peak. They were hoping that nobody would pay attention after Justin Baldoni's lawsuit was dismissed, which they can still appeal, by the way. I know they told TMZ that they can't. TMZ, led by Harvey Levin, who is actually an attorney himself, put out wrong information. Brian Friedman called him out on that, and their retraction was extremely quiet, right? There's still a chance to appeal that. It's not over, right? But his, lawsuit was dismissed. And so they want to act like everything is over and Blake Lively won. No, the core complaint, her complaint, is still very much in play. So, yes, the presumption of public access is at its peak. You presented it to the public in a big way. So, Lively also seeks to seal the identity of other witnesses. Right, of course. One sec, guys. And I would just ask quickly that you guys hit the like button for me if you haven't yet. I really appreciate it. It helps me out. And, it's free. So please hit the like button. I keep forgetting to do that. And then other YouTubers will be like, Lauren, you need to tell people like and subscribe or whatever. I'm like, yeah, but I don't want to do that. But I guess it does help. So if you could, please. All right. Let's see. First, she seeks to seal the identity of a crew member who discussed filming with the film's intimacy coordinator. Okay, that's pretty relevant. Lively identifies no privacy interest whatsoever concerning the crew member, and none is apparent from his communications. Next, Lively seeks to seal references to Lively's personal staff, even though their names were already made public by Lively herself when she identified those individuals in her initial disclosures and stated no objection when those disclosures were filed on the public docket weeks ago. Okay, so I don't even know who they were referring to, but apparently it's already public information. So, right. One second, guys. Okay. Sorry, I'm just trying to work something out here. Just take a second. And we're good. I got it. Okay. Cool. Next, Lively seeks to seal references to her personal staff, blah, blah, blah. She also has cited them as witnesses supporting her case. Okay, well, what the fuck? What are you complaining about then? Okay. Although Lively claims some of these individuals suffered harassment when their names were initially disclosed, She offers nothing to suggest that disclosing the additional information would cause any further harm. Okay. I don't know who she's talking about other than Ferrer, potentially, who put out her own motion to seal. So I genuinely don't know who they're talking about here. Finally, Lively seeks to seal information about her compensation for the film. That information has already been publicly disclosed without objection, and it is directly relevant to the independent contractor issue raised on summary judgment and to Lively's damages claims. Lively also claims those documents should be sealed because they divulge WME's commission rate, but WME itself does not and cannot claim that information is competitively sensitive because it is the industry standard. So, for the foregoing reasons, the bulk of Lively's sealing requests should be rejected. So that was the only one I wanted to really go over in full. I think the rest of them we'll probably just skim through. There's a couple that are related to Blake's businesses. Hang on one sec. Let me read these real quick. Lego spawning floor, round room, no door, /light 4BL. I think I saw this one earlier. Thank you, Ricardo, again. User S19, thank you for the £2. Subpoena Gate will never be forgotten. No, I'll never forget it. I love how direct and hard they're called out. Finally, thank you again for the £2. I appreciate you. April Love 360, thank you for the $5. Talking out the side of their necks. New media that don't get protections. Public figures getting third-party anonymity. Make it make sense. Dude, I know. Thank you very much. And Lottie of Wales, thank you for the $10 super sticker. Good to see you again. Thank you very much. Appreciate that, guys. All right. Let's run through a little bit more of this, and then I'll redirect you guys to that video about them asking for Ryan Reynolds' messages to be released. But let's go through this shit first. Hang on. Okay, so we have... This one is related to Family Hive LLC. That's one of Blake's businesses. So let's see. I haven't actually read through this one yet, so I'll try to skim through a little bit where I can. Wait 1 second for water and black coffee here. Oh, I did it. I finished the cup of black coffee. Okay. Spotlight shifts as they eviscerate Sony sealing request 2. Forget which document. Yeah, we'll get there. I have it up, but I haven't gone through it yet. So Spotlight shift is going to be on the show soon, guys. I don't know exactly when. Maybe when I get back into town after I go out, but we'll see. We'll work it out as soon as we can. So this one is for Family Hive. I don't think there's too much we need to see here, but let's see. The court has been asked to rely on the materials Family Hive now seeks to seal in determining the Wayfarer party's summary judgment motion. For purposes of evaluating the motion for summary judgment, the court should not seal any documents that Miss Lively produced and place squarely at issue as a basis for her damages, especially when Family Hive cannot identify any competitive harm that might result from disclosure. So Blake Lively basically said that she had all these damages because of the PR effect, or that the effects on her reputation. She blamed the Wayfarer parties for it. And then these businesses who come out and say, well, Blake doesn't own that much stake in them. And like, no, it's not that, you know what I mean? So like you pick a lane. It's either you own these businesses and they've suffered because of the Wayfarer party's damage to your reputation, or it doesn't really have anything to do with you. You have to pick one or the other. So it's ridiculous. All right. See. Family Hive seeks to seal the following documents. Deposition pages. Right. Family Hive seeks to seal portions of pages from the deposition of its Rule 30b6 witness. Page 137, which it seeks to seal, concerns discussion of Family Hive's retail weekly sales. Blah, blah, blah. That is, wow, really boring. Ms. Lively has placed the information directly at issue regarding her claim for damages related to Family Hive in excess of. So she says they have damaged her reputation and therefore Family Hive, her business, in excess of this certain monetary amount. But then she wants it sealed. Right. Finally, the identity of corporate non-parties who Family Hive wish to conduct business with does not implicate privacy concerns. Right. Lively expert Jeff Kinrich report. Family Hive seeks to seal portions of the expert report The fact that Mrs. Lively's expert relies on Family Hive's information establishes the information's relevance to the motion for summary judgment. Right, that makes sense. I'm going to skim through this one, guys. Okay. Family Hive sales performance, blah, blah, blah. Okay. Lively expert Dina Maislin. Is it Maislin? I think. Family Hive seeks to seal portions of the expert report submitted by Maislin. The proposed redactions all relate to Family Hive's sales performance, which is the basis of Miss Lively's damages claim and the subject of the argument that she claims damages are too speculative. What? The subject of the argument that Miss Lively's claim damages are too speculative. Huh. All right, then. As Family Hive has not met its burden to overcome the right to public access, the court should decline to seal. I agree with that. It doesn't sound like any business breaking information is being put out there. I don't really understand why that would be sealed at all. But we'll pass over the Betty B one as well because it's probably going to be the same type of stuff. And let's move over to Sony. How about that? So we got Sony, and then I'll leave the Jonesworks stuff for a later time because it has mostly to do with the Rebel Wilson case. Like I said, these are the only two documents we have left. So I'm going to leave that one out, and we'll just do this Sony one, and then we'll move over to the Ryan Reynolds messages video. Okay, hang on one sec. All right. So, dear Judge Lyman, on behalf of Wayfarer, right, we write in response to non-party Sony's motion to seal. With narrow exceptions, the documents at issue relate directly to the subject of the summary judgment and spoliation motions, as well as Ms. Lively's claims and the Wayfarer party's defenses, and should not be sealed. Okay, that makes sense, right? As this court has correctly observed, the presumption of public access is at its highest when the material is relevant to a court's decision on a dispositive motion, such as a motion for summary judgment. Where the presumption applies, continued sealing of the documents may be justified only with specific on-the-record findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. Right. Sony's requests are largely based on the notion that the documents at issue have no relevance to the judicial function. That is wrong, as explained below. Each of the items Sony seeks to seal is directly referenced in and relevant to the motions at hand, where it provides valuable context for the court's analysis of those motions. Right. I can zoom in a little bit more in case people can't read that. Okay. Sony's contrary view of relevance is far too cramped. Cramping their style, right? Cramping like that? Okay, I don't think so, but I'm just being ridiculous. As the court has ruled, a document is relevant to the performance of the judicial function if it would reasonably have the tendency to influence a district court's ruling on a motion or in the exercise of its supervisory powers without regard to which way the court ultimately rules or whether the document ultimately, in fact, influences the court's decision. Okay. Right. In light of the strong presumption of public access, Sony's vague invocation of unspecified privacy interests cannot justify sealing because continued sealing may be justified only with specific on-the-record findings that sealing is necessary to preserve higher values and only if the sealing order is narrowly tailored to achieve that aim. Got it. Sony primarily seeks to seal comments its executives made about the events underlying this dispute. As this court has acknowledged, a generalized concern of adverse publicity is not a sufficiently compelling reason to outweigh the presumption of access. Right, got it. The information at issue bears on the parties' claims and defenses, and it does not disclose anything private about any Sony employee or competitively sensitive to Sony. It should not be sealed. Okay. We can skim that. Sony seeks to seal line whatever of Exhibit 12, the deposition transcript of Sony executive Ange Giannetti, in which Ms. Giannetti confirms that she told Heath she thought Lively was, and then it's redacted. They have to keep redacting this stuff until the judge rules on this. So, unfortunately, there's still going to be a lot of stuff we can't see, right? Skim some more. The material Sony seeks to seal is directly relevant to the dispute at hand and supports the Wayfarer party's defenses, including because it weighs heavily against Lively's contention that she... don't know. It's sealed. So, okay. They have another example here. The documents concern Lively's performance in the film and or the subsequent social media backlash, and were cited in direct support of undisputed material facts on which the Wayfarer parties rely in support of summary judgment. Sony identifies no countervailing privacy interest that could be harmed by unsealing the language it seeks to redact. Right. Let me skim this real quick to make sure there's nothing relevant. Yeah, no, we're good there. Okay. 1 second, guys. Okay. Georgie XE6GY, thank you very much for the $5 super sticker. I appreciate you. Thanks for being here. All right. Let's see. We're talking about another document here, and unfortunately most of this is sealed. It says they were directly cited in the Wayfarer party's 56.1 statement. Though Sony proposes redacting language not directly quoted by the Wayfarer parties in her Rule 56.1 counterstatement, Lively refers the court to the cited sources for their complete contents, putting these documents at issue in their entirety. Okay. Again, I don't know much about what that is because they had to seal a lot of that. So then we have another one here. It's a memoranda in opposition to spoliation motions. Sony asked the court to redact documents in which a Sony executive called Lively a... Wait, wait, what does that say? That could say anything. That could say anything. I need to know what it is. But anyways, they're trying to keep that sealed, I guess. Sony does not dispute that the information it seeks to seal is directly quoted in the Wayfarer party's moving papers. Thus, Sony's contention that the quoted material has no bearing on the underlying motions is inaccurate. Okay. Sony further argues that unsealing the text and quotes would reveal potentially embarrassing conduct. Then don't do it. I mean, but ignores the fact that embarrassing conduct is traditionally considered private rather than public only when it has no public ramifications. It's not like you accidentally farted in church. Like, okay. Yeah, it's a little different, bro. Here the information reflects, and there's redacted stuff. So such information certainly has public ramifications, and any ensuing embarrassment does not outweigh the interest in public disclosure, especially for a dispositive motion. Even if you farted in church. I'm sorry. Okay. Oh my God. Okay. Anyways. There's a Gottlieb declaration with stuff they want to seal here. It says the material Sony seeks to redact from these exhibits is based on opinions and testimony by Lively's expert witnesses. Lively did not seek to seal this information. Sony's proposed redactions for paragraphs blah, blah, blah do not cite or quote from any material produced by Sony or any of its employees. The same is true for Sony's proposed redactions for Exhibit 17. Lively's experts base their opinion on evidence of Sony and its employees' actions, demonstrating the relevance of this evidence to judicial function. A non-party's desire to avoid public criticism by a party's expert witness is not a cognizable privacy interest that can outweigh the strong presumption in favor of public access to materials submitted in support of or opposition to summary judgment. The Wayfarer parties respectfully request that the court deny Sony's motion set as forth herein. So hopefully the judge will rule on this before the hearing, because they're doing oral arguments on this, like I said, in less than 10 days. And I'm hoping to be out there for that, but I don't know. There's lots of stuff I can do in New York while I'm out there, so I would just, love to attend in person. I don't know. We'll see. Like I've said before, if I were to go to that, I know how to conduct myself in courts. It's not like I would ever badger anyone. I expect that the parties won't be there. I would expect only the lawyers to be there if it's an in-person hearing. If it's not, I probably won't go out to New York. Like I said, I'll get a flight refund or whatever. But if I can go out there and just hear the lawyers argue, I think that'd be cool. I would like to experience that. So we'll see how that goes, but I don't know. Try putting cinnamon in the black coffee. It helps. I don't have any cinnamon. I'll have to get some cinnamon. We'll see. I'll try to remember to do that. The odds are that I will not remember to do that, but I will try. I will try to remember. So, all right. Guys, I have another video out because there was one more document that I thought was pertinent to read tonight, and it was that Justin is asking that the judge unseal Ryan's messages with WME. So I'm going to put a link to that right here, and I'll change the premiere time to right now, or like 10 minutes from now. And you guys can watch that, and then I'll be back tomorrow. So let me edit the premiere time. It's right now it's 8:27 Eastern. So let me set the premiere to 8:30. So it'll start in like 3 minutes. Yeah. 8:30 p.m. There we go. Done. And then I'm going to set the premiere countdown to like 3 minutes. Right. So, well, you know what? Why don't I set it to like 1 minute? 3 minutes is annoying, right? Let's premiere. Today, 8:30. Done. Set up. Let's do 1 minute. Okay. I put the link there, but as soon as we're done here, there should be a message that pops up on the top of the live chat here that says the link to go there. And there will be a live chat during that video. So you should be able to chat there if you want to continue chatting or whatever. And if you're watching this tomorrow or later on after this live has ended, I'll put a link to it in the comments. So appreciate everyone if you can. Also, by the way, guys, I know it's really hard to get notifications on YouTube. They only give you like a certain amount every 24 hours or something. So if you want notifications when I'm going live or when I have a new thing public or when I post something, you can always go here to Patreon. You don't have to pay. It's a free thing. So if you want to be a free member of Patreon, if you pay to be a member on Patreon, you get the same access as like a member, a YouTube member. I'll put a link here in the chat as well. And that will also be in the description of this video. So I will see you guys over in the premiere for the next video, which starts in 1 minute. So thanks very much. Appreciate it. And I'll see you all soon.